2, 1.
Okay. Welcome everyone to today's webinar. We will begin shortly, and we're just waiting for people to join the presentation. We'll say that the recording today is recorded. The presentation is being recorded, and it will be sent out afterwards, together with the recording.
Just wait another minute to give people a chance to get into the meeting. Start 8:32 presentation.
Yes. So we noticed that people are attending the webinar today. Everyone is very welcome. As stated earlier, this session is being recorded, and the session together with the presentation will be sent out after the webinar.
We also say that there will be a Q&A in the end, but if you have any questions during the presentations, feel free to write your questions in the chat.
Yes.
There we go.
Yes. Okay, so it's 8:32, and we will start the presentation. We'll start with welcoming everyone to today's session. As said earlier, it will be recorded, it will be sent out, both the recording and the presentation. Speaking today is me, Doug, and me. I work as a senior associate here in Rouse, Sweden. I've been with Rouse for 5 years, and I work on various commercial matters as well as trademark issues, and also hold a master's degree in international commercial arbitration.
Hi, I'm Doug Clark. I'm going to be doing most of the presentation with Mu and Lava today. I'm, as it says there, the Global Head of Dispute Resolution with Rouse. I joined 2 years ago, based here in Hong Kong. Prior to that, I'd been a barrister in the practicing the Hong Kong courts, and prior to that, I practiced in China for 10 years as the managing partner of another firm's office. In total, in February next year, I will be practicing law in Hong Kong and China for 29 years. I went to university in China many years ago, so I speak Chinese, and also went to high school in Japan even many more years ago and speak Japanese as well. I'm currently sitting as an arbitrator in 3 cases involving Chinese parties, and I've also been counsel in many arbitration cases involving, well, Chinese parties, but also many other parties as well.
Yes, and my name is Mie Mattsson, and I'm also a legal counsel and senior associate at the Rouse in Stockholm office with Love. And I just joined Rouse earlier this year. And my background is from different law firms, and I've been to the district court here in Stockholm as well. So that's about us.
Yes, let's head into today's agenda. We said it earlier, everyone is very welcome to post questions during the presentation. You do that during, it's a sign on the screen, and you post a question, and then we'll distribute that question among ourselves here. So feel free to jump in, and we invite you to do that. So today we'll talk a little bit about Rouse, who we are, what we do. And then we'll head into a short introduction to the topic and the main issues we see. And when it comes to choosing a way of adjudicating your dispute. And we'll move into RP arbitration in Asia and the current trends there. Touch upon the subject of whether to choose arbitration or litigation. and also look at some practical issues and then end with some key takeaways. We'll see if we will manage to go through all these topics, but this is the agenda we have for today.
So about Rouse, we are a global IP service business, and we started 30 years ago in the UK with Peter Rouse, who saw the need for Western companies to get help for to join the market in China, in Asia, Southeast Asia as well. So today we have 18 offices in 13 different countries. 650 something about that people all around the world. So you can see here on the map where we have our different offices. 5 of them in China. In Southeast Asia we have, for example, Indonesia and Vietnam. Yeah, so you can see it's been a few more offices down the years here.
So the introduction then, there are typically some main issues we see when the clients come to us. And then the first question is, what type of dispute resolution clause should we choose? Should we have arbitration? Should we have litigation? And we generally see in contracts that we draft that arbitration is chosen as a mean of resolving the dispute, for instance, in license agreement. And then if clients choose to go to arbitration, the question arises where to arbitrate. Sometimes a contract is being drafted between parties that are from the same jurisdiction, and then it could be natural to choose the country where both parties have their place of business. But sometimes a contract is between different entities in different parts of the world, and then they have to agree on another part. And then we have to look at the law where the arbitration is to take place, and also make an assessment if that place is a good place to arbitrate the IP dispute. And then also issues that you have to consider is enforcement of a judgment in case of litigation, or an arbitral award if you go to arbitration. Generally, foreign judgments are not enforced in other jurisdictions. However, arbitration awards are under the New York Convention enforceable. And then also have to consider that even if it's enforceable, is it easier to enforce an arbitral award than a foreign judgment?
Okay.
Yes.
Yeah. Okay, so we're focusing now on IP arbitration in Asia, and so there's been a large increase in disputes. I started doing arbitration involving IP rights in Asia in about, I think, 2007, but there were a relatively small number of cases then. But since then, we've seen a very large increase. This graph was published recently. Unfortunately, it wasn't published with the colours for the cities. The point was to show a very rapid increase. I think that's Singapore, of arbitration cases generally. But even for IP cases, we've seen some very large increase in cases. Both the Hong Kong International Arbitration Centre and the Singapore International Arbitration Centre have actually set up specialist panels to deal with IP cases, because they're appreciating the general arbitrators could not deal with those. And I'm on the HKIAC panel. I'm waiting to hear back from the SAIC. Some of the claims are huge. Some of the claims are in the hundreds of millions of US dollars, much bigger than you see in litigation in court, being decided through arbitration. One of the reasons for the increase is something that Lerva just mentioned, but specifically applicable to China, is foreign judgments are very, very rarely enforced in China. In fact, I'm only aware of 2 that's ever been enforced, but very rarely enforceable in China. And so having an arbitration clause is much better, because China is a party to the New York Convention, and you can then enforce awards, foreign awards, even in China.
Doug, as you told us, you have a lot of experience with arbitration in China. What are the main types of cases that you see in IP arbitration?
I think, as mentioned earlier on, Obviously, licensing contracts, we're seeing very commonly in licensing or technology transfer contracts that people are including arbitration clauses. And of course, to be able to arbitrate, you have to have an agreement to arbitrate. So you don't see so much infringement. I'll talk about that a little bit later. We don't see so many infringement disputes per se. However, even under a license contract, very often the arbitrator has to determine if IP rights have been infringed or valid, particularly taking a patent license as an example. In a patent license, very often it is that you pay your royalty on the basis that the product infringes and the IP right. And of course, then validity becomes an immediate defense to that, saying, well, we don't have to pay a royalty because your right is invalid. And so many of the arbitrations I've been involved in have turned around effectively the infringement or validity of patent rights. However, normally the underlying dispute is still a breach of contract. You are still bringing a breach of contract claim, but asking for decisions around the validity and infringement of IP rights so that the contract can be enforced or not enforced, depending on which side you're on. But there are, as I mentioned, occasionally infringement disputes.
What about IP infringement disputes then?
Very not so often. I've had one case, actually three, but it was all the same parties, cases where infringement disputes were arbitrated. The main reason why you don't get it is if people are if one party thinks one party is infringing its rights, there won't be an agreement in place, so you can't automatically arbitrate. You don't have to try and get someone to agree to arbitrate, but one party will often feel, well, I have an advantage in a court case. For example, if you're a Chinese party and they've been alleged to infringe in another country, it's like, well, you can't enforce that judgment against me in China. Why would I agree to arbitrate? Or it may just be that you think you're going to be better off getting an interim injunction in certain jurisdictions and you don't want to actually necessarily arbitrate. That can change during the course of a case. I've had cases where we've proposed arbitration. The other side said no because they felt they were feeling strong in court. We've got some interim relief or something like that, and suddenly they turn around and say, actually, that arbitration idea, why don't we deal with that? And then you say, well, it's too late. We've just spent all the money on court cases, so sorry about that. You do see some being arbitrated. I mentioned already for settlement agreements. That's the three cases I did involved a settlement agreement. It already provided, saying, hey, we've been litigating so much, why don't we arbitrate any future disputes? Competition authorities occasionally, particularly in relation to standard essential patents, had in the past, less so now, but had in the past encouraged parties to arbitrate. So you'd see that come up occasionally. And you do see the occasional reasonableness between usually larger parties in the industry and say, we've got lots of litigation potentially going on around the world, 9 or 10 jurisdictions. Let's just bring it all together and get one arbitrator to decide that. So avoiding that expense and hassle of cross-border litigation. So you do see it, and you can arbitrate pure, well, subject to what we're going to discuss a little bit later, you can arbitrate pure infringement issues as well.
Right. So from your experience, Doug, can you tell us about what are the advantages of arbitration?
Okay, well, we've got a slide up there, of course, but everything I say is an advantage of arbitration. I have to point out one side may see as a disadvantage, and even throughout a case that may change. So, for example, in many countries, arbitration is secret or meant to be kept confidential. So Hong Kong and Singapore, arbitration is specifically confidential under the arbitration ordinance or the Arbitration Act, and the rules make it secret. Parties can always agree to secrecy. In China, some of the institutions have secrecy, some ones don't. That's why the question mark there is that you have to check. But the parties can always agree to secrecy in arbitration, and that will be enforceable. That can be very valuable for a patentee, for example, who they know that if they bring a claim, someone's going to challenge the validity of their patent. But if that's done in an arbitration, no one knows what prior art's been cited, and no one even should know the ultimate decision if it's been found invalid or not infringed. And that can be very valuable for a patentee who has multiple licensees. So sometimes they want to arbitrate for that reason of secrecy. And of course, the licensee will often then want that to be public, because one of your best threats in any dispute over patent rights is that I'm going to invalidate your rights, and then you lose it to the world. And in an arbitration, that threat is much weaker. Probably one of the biggest reasons now, and why the HKIC and the SIC set up specialist panels is specialist lists, is because you can have a specialist decide your case. Rather than going to court, where in many jurisdictions you'll get a generalist judge or a judge who may be a specialist in something else but not IP, and that can be very, very valuable because it can save a lot of time, which I'm about to come on to. And again, though, sometimes you don't want someone to specialist deciding your case because you've got a weak case, and so you may prefer to litigate. Cost is a big issue because it's not necessarily cheaper, because you've got to pay the arbitrators, you've got to pay for the facilities for the arbitration. But if you have a specialist panel, things should be faster. And as a general rule in litigation or any type of dispute resolution, when things are faster, they are generally cheaper. Because you're not spending so much time or relearning things. And so, for example, when I sit as an arbitrator, and all the arbitrations I've been counseling, every arbitrator has set a pretty fast timetable, which is also a point I have there. You know, we'll hear this within 15 months to 18 months. We'll work backwards from that. We'll do pleadings, we'll do document disclosure, we'll do all those things and get through to a pretty fast result, which can be both cheaper and, of course, much more time efficient. So there can be, if you get the right arbitrator, some great advantages.
Yes, and I would like to add that for our Swedish viewers, that in Sweden you have to agree to secrecy in arbitration. It's not something that comes as a standard. There was a case a couple of years ago from the Swedish Supreme Court, which stated that the secret was something that you have to choose, and that choice actually has to be made when you draft your agreement, if it's a secrecy agreement or a licensing agreement. So we recommend that if things are to kept secret, that you think about that when you draft your agreements, which then obviously a dispute can be very look like it's far away, because you want to cooperate and do things together and you're still friends, but consider the secrecy aspect. That's our recommendation.
A very good point, Lova. And in fact, yeah, whatever, and we're going to talk about clauses a little bit later, but whenever you're looking at arbitration clause, you can't just put in, we agree to, for example, arbitration in Stockholm in whichever institution, because you need to read those rules and see what they provide and make sure those rules are providing you what you want if you get to arbitration. And the point about secrecy is very important. It's many places there is a movement against secrecy in arbitration, and so you have to make sure that that is what is provided.
Yes, and some of our clients, they're afraid of what they call the David and Goliath situation, where it's a big actor on one side and a smaller company on the other side, and then they don't want to yell out to the world that we are in a dispute with the smaller firms and we're stepping on their toes. So, and having arbitration and keeping it secret could be a big advantage to the public perception of your firm.
Yeah.
So we come into the issue of validity of IP rights and whether or not they're arbitrable. This is usually seen as a public policy issues. Could you please develop, Doug?
Yeah, sure. It is a big public policy. I'm not actually sure personally where I come down on this, because IP rights are granted by the state, and because of that, they do raise a big public policy issue of, particularly if you have secrecy, should their validity be determined in secret and never be known to anyone else because of that, or should you require the parties to bring any challenges to validity to whichever body you have that decides validity, whether it's a patent office or a court, so that everyone will know the status of this IP right, generally a patent, but it could be a trademark as well. And that's because these rights affect everyone. They affect all third parties. You want to be able to look at the register and see if a patent's valid or not, and if it's been decided in arbitration it's invalid. That's secret, and it doesn't even affect the register. So some countries do not allow the arbitration of validity, and that includes China. We're going to talk about that a little bit later, how that impacts arbitration involving Chinese parties, particularly if you want to enforce in China. South Africa being another one that doesn't allow arbitration of validity. Most places actually do allow for validity to be arbitrated, but only inter partes, which means that the decision is only binding between the parties and it doesn't affect the register. And again, that's a very difficult public policy balancing act, because of course you don't necessarily want to have to stop an arbitration for someone to go off and get validity decided, particularly if the courts are very slow. So it is good that an arbitrator can decide that, but then we have the problems I've just discussed. And some very small number of countries allow an arbitral award to be the actual formal basis for an invalidation, which is Switzerland. But that has its problems as well, because the arbitrator may have just got it wrong. And then why should you lose your patent, right, if an arbitrator has gone rogue or something and found a patent invalid when really it's not? And so that mixture of issues just makes a big public policy issue. But legislators have generally come down to this inter partes validity being decided. But as I said, for China it's different, and we will have to. And if you're doing anything involving China, you're going to have to deal with that.
So that leaves us the question if disputes of registered IP rights are arbitrable or not.
Yeah. So we just talked about validity and specifically, and so the question of infringement. So that's just going back to that license agreement example I gave you. You have to pay a royalty if the patent is infringed, is how it's often drafted. Most jurisdictions have no problem with that, so yes, you can decide that, because that's really not a public policy issue. That's just deciding around a product that you've made. Does it infringe a patent or does it infringe a trademark? It's not such a big public policy issue, except in South Africa where they don't allow it. And I've mentioned that the validity is different around the world, and this is what creates the problem. Because your main defense to an infringement claim is usually that the right is invalid, or at least particularly for patents. You're usually going to say, well, that patent right is invalid, therefore I don't infringe. And in fact, in most court cases, that's usually the result too. If you often infringe, but it's an invalid patent. And so that can be a real problem, because the license says you have to pay royalty if you infringe the patent, but then if the tribunal has to decide validity, they may be running up against the public policy issues. And the most important public policy issue may be that even though you can decide that where in your seat of arbitration, when you come to enforcement, you may face a problem, because the New York Convention has a specific provision that it's not that a court may refuse enforcement if the subject matter of the difference is not capable of settlement by arbitration. And we mentioned already, under Chinese law, validity is not capable of settlement by arbitration, so you get a problem of what are you going to do if you bring an arbitration, and validity is an issue that needs to be determined to decide if someone owes royalties or not. The Chinese courts may, I haven't actually seen it come through the courts, but the Chinese courts may say we can't enforce that because of this problem.
So, are there any special rules providing for arbitration of IP rights in particular?
Yeah, so I've already mentioned China has its special rule that you can't arbitrate validity of patents and trademarks, but in Hong Kong and Singapore, particularly Hong Kong, the government's gone to the extreme of providing in the ordinance that every issue around IP rights is arbitrable. So our ordinance was amended in 2018, and they give the arbitral tribunal explicit power to decide any issue around IP. And that includes a very specific provision that says the tribunal may determine infringement and validity even if the law of Hong Kong or another place provides only a designated body may handle that. So taking China as an example, the Chinese arbitration law says you can't arbitrate administrative things that are decided by administrative bodies, which is patents. Even though it says that, a Hong Kong seated tribunal is allowed to decide that. In fact, technically in Hong Kong, only the court can decide validity as well, but this overrides that as well and says the tribunal may decide that. It is, however, said specifically that the award only applies inter partes, so only between the parties to the contract, and it does not affect a third party, with one exception, and it is something to think about when you're contract drafting, particularly if you're a licensee. If the parties agree an arbitral award between other parties will be binding as to validity, then it will affect another license, but you have to have agreed it in advance. And now you may or may not want to do that. Obviously, the patent's found invalid, you want to do that, but if it's found valid, maybe you don't if you're a licensee, or vice versa. But it does give the benefit that you can take that. It's very good for a patentee, and I've seen this. I've seen patentees very happy to arbitrate in Hong Kong on this basis because the validity is not going to affect their rights anywhere in the world. I'll just mention that it's the last bullet point. Singapore is amending the law to do the same thing as Hong Kong, but their common law probably already provides for this as well, because the Hong Kong common law provided for it, and Singapore and Hong Kong have very similar common law. One thing that comes out of it in Hong Kong is tribunals, including myself, have found that we have jurisdiction to hear standalone infringement cases between the parties because of the breadth of the arbitration clause. So there'll be a license claim, and then a party may say, well, on top of the license claim, we want you to find that there's infringement of some other rights or the same rights separately. If for whatever reason a license doesn't apply, we want you to find infringement. There's a case called Fiona, Truss and Pavlov out of the UK House of Lords that says all reasonable business people will be assumed to have wanted to resolve all their disputes by the same tribunal. And so there's a presumption of deciding things within the arbitration. And for that reason, many Hong Kong tribunals have found that they can deal with these issues.
Yes, and we just noticed that a lot of other people joined our webinar, and we're very happy about that. And we'll just say that the webinar is being recorded and it's being sent out afterwards together with the presentation, and that you're also welcome to today's session. We just touched upon arbitrability issues, and how do we solve these issues?
Well, one of the easiest solutions is if it's a dispute over damages or royalties, particularly if it's royalties, rather than drafting a clause there, they can just it's just going to be arbitrated. You put terms in your arbitration clause saying either, all we want you to do, if we have a dispute over royalties, all we want you in your award to say, you can consider it all these things, but give us a number that's owed. Don't make a finding that a patent is valid or invalid, or a trademark's valid or invalid or infringed. Just say, all these issues have been brought before me, taking everything into consideration, I order that you pay X, or you don't have to pay anything. Is one simple way to deal with it.
Yes,
you see that in America.
Sorry. So this can be agreed when the contract is being drafted between the parties, but also after a dispute has been.
Yes, it can be always better to agree in the contract if you're because once a dispute arises, it's very hard to get people to agree. But particularly if they're from different cultures, different legal cultures. But yeah, obviously, if you can do it, you can try and do it also after the dispute arises and it's done. Another way is you can even just say you can take account of your views of infringement and validity, and you can even set them out in the award, but don't make a final determination. Set it out so the parties get an understanding of what you're thinking, and then say, on the basis of my views, not my finding that it's valid or invalid or infringed, you should owe X. And I think that will work. I've seen it in clauses. Again, I think it takes away the real bite of your saying it's valid or invalid. Sometimes you can just ask them for an amount payable. Americans do this quite a lot. They just say, because that's partly for discovery rules in America. And you can also sometimes agree a high or low number if you're doing a negotiation, saying, okay, no matter what, you'll pay a minimum, and even if the arbitrator awards more, you'll pay a limited amount. But that's not so much to do with the arbitrability issue. That's about if you're trying to agree a mechanism for avoiding it, you can also put those things in there.
Okay, moving on. Can you get an interim relief in arbitration?
Yes. it is ordered. Often in an IP dispute, if even a license agreement, you may need an injunction to stop someone producing stuff. You say they're no longer licensed. You may want to freeze assets. And more recently, big issue in FRAND licensing is that you may want an anti-suit injunction. I've in fact granted one in one case because we had an arbitration clause, and one of the parties applied to invalidate the patents in another country, the relevant patents, and we granted an anti-suit injunction saying you can't do that. We've agreed to arbitrate. For injunctions, arbitration worldwide, you can apply to the arbitrator if you've had one appointed, and he can give an interim award, and then that can be, you can try and enforce that in different courts depending where you are, or you can go directly to the courts in most jurisdictions, because it's accepted that for interim relief, going through an arbitrator may take too long, or you may not even had an arbitrator appointed, so you can go to the courts. There is an interesting development, very interesting development in relation to Hong Kong seated arbitrations involving Chinese courts. New rules came out a couple of years ago now, that you can get interim relief from the Chinese courts for arbitration seated in Hong Kong. And it's been used a lot. There's been, I think, 56 letters of request now to the HKIAC to support interim relief, and the Chinese courts have been granting injunctions. Most of them, in fact, I think all bar one, so 55 out of 56 have been to freeze assets. And interestingly enough, it's not necessarily the assets of the Chinese party. I think the statistics I heard from the HKIAC recently were about 60% of the applications to freeze assets of the Chinese party, but 40% have been to freeze the assets of a foreign party, you know, their holdings in a joint venture or their holdings in something else in China. So it's been used by both sides to freeze assets. Couple of points I put down there. I won't go into them in detail because I want to get to some of the more bigger issues. But main issue is you do need to file the arbitration, and you do need to actually get a Chinese law firm in to apply for the injunction before the Chinese court, and that can take some time with notarization and legalization.
Yeah, and we've been onto this topic a bit previously, but is there anything you'd like to add about? Is it possible to get an agreement when a dispute already has arisen?
I have tried numerous times to do this, and I failed every time, to be honest. Always one party doesn't want to or not. The only case I've ever heard of, I'm sure there's more, it's called a submission agreement. So they actually, all the institutions have submission agreements, and I'm sure people have got them. In IP, I've always found it impossible, because once litigation started, someone always thinks there's something, you know, they got an advantage or not. And particularly some licensing agreements, people may even be suing, or some infringement issues, people may be suing in multiple jurisdictions and want to do that. And also, frankly, for example, in FRAND licensing, often the courts have now moved on that you can sue on 1 or 2 patents and still get a license terms ordered, particularly in the UK and now China. Whereas if you did an arbitration, you may have to involve multiple patents. But there are ways to, and the best way I've heard, I did hear, I went to a presentation in America years ago, and they were talking about how they got to a submission agreement. And the main way they did it, so the plaintiff had sued, and then the defendant was challenging the validity of the patents and everything, and the plaintiff didn't want that, of course. So they proposed arbitration, and the defendant said, well, why would we want to? And they said, well, the plaintiff said, well, we're claiming $2 billion now in court. To get you to arbitrate, we will agree, no matter what the arbitrator decides, we will cap damages at $600 million. And the lawyers still said, well, we can fight you, we're not going to have it pay up $600 million. But the CFO of the defendant company thought that was fantastic, because he suddenly releases $1.4 billion as a contingency from his accounts, which is big, a big release. And so they agreed to arbitrate. So you need to be thinking, what advantage can you offer the other side other than just arbitration to do that? And so that's the one that I've seen. The other thing I've seen occasionally, and this is more relevant directly to IP, is you can say, look, we'll agree to arbitrate now, and we will even agree to grant you a license if you're found to infringe. on terms, either agreed terms, pre-agreed terms, or the arbitrator can even set the royalty rate. And that can be very attractive to an alleged infringer as well, because one of the problems of litigation, no matter how confident you feel, is that if you lose, you may be injuncted and you have to pay damages and other things. But the injunction is big because it still takes a year to 18 months to develop a lot of products, and the threat of being injuncted is going to make it much more difficult to develop. So if you get offered a license, you know that at the end of the arbitration there's a license that you'll just have to pay money under that. That can be very attractive, plus whatever damages, whatever, but you know that you won't have to stop producing that product. That can be very attractive if that's what the plaintiff is willing to offer. So that's one, but otherwise I find it almost impossible. It's difficult.
To summarize it, it's to recommend to discuss this when you are drafting the agreement, right?
Oh, yeah, well, sometimes you can't, of course, because infringement arises with parties that sometimes never knew of each other at all, and they never had any type of relationship. So obviously, then you have to try and get it after the dispute arises, but very hard, very hard. Not impossible, but very hard.
I guess one argument as well is that arbitration can save considerable time, because usually arbitral awards are not appealed. Yeah. Or they could be appealed, but that's on formal mistakes from either the arbitrators or so. But so if you are in a litigation, it can go on for years and go in several instances.
Well, don't forget, some defendants like litigation going on for years. Because then you just keep on producing, and you keep on making money, and eventually you move on to another product even before litigation settles. So if you've got a slow court system, you may be quite happy to litigate rather than arbitrate. So more attractive in a fast system where there's fast litigation.
Yes, so moving into the practical tips section, what tips do you have for handling IP arbitration?
It can be probably the biggest issue is you can end up dealing with multiple legal systems. Most arbitration, in commercial arbitration, you'll have agreed a contract, and let's just say, because I'm in Hong Kong, most of the contracts I see says be arbitrated in Hong Kong under Hong Kong law, so you're just deciding everything under Hong Kong law. But once you bring IP rights in, and say particularly patent rights, and there are issues around infringement and validity, the only logical thing to do is to decide those under the law of the place the right is granted. You can't decide whether a Chinese patent is valid under Hong Kong law. You can't decide if a US patent is infringed under Hong Kong law. Now, very often it's the same, because worldwide we have treaties and provisions that make this similar, but there are differences. For example, doctrine of equivalence is applied in different ways in different countries. Certain countries have different rules about what is prior art. For example, Hong Kong and England have very strict rules that if something's been published anywhere ever, it's prior art. US doesn't have that. So there are things that are different. And so you may have to determine issues under multiple laws. So you need to be trying to find people knowledgeable in multiple laws and take that into account. Languages to be used, and that can be a combination of various things. For example, some people want to agree bilingual, a little bit dangerous simply because then you need bilingual tribunals, bilingual counsel and everything. But you can still agree, like, okay, documents don't have to be translated, because a lot more people can read or people can deal with it. So you can say languages, we're going to do in English or in Chinese, but other documents don't need to be translated, because finding people who can read another language is much easier than finding people who can fluently speak both and read those other languages. Your seat of arbitration, where will it be? As I mentioned already, if you can get interim relief. So for the moment, if you want to arbitrate outside mainland China, Hong Kong is a great choice if you want interim relief in China because of the procedures I just talked. Singapore doesn't have it, and others don't have those provisions. So that can be important about where the seat is. Also, what's the seat's attitude towards review of awards is something you just mentioned, Lava. Sometimes some countries, very strict rules, only going to challenge on whether the law was wrong. Hong Kong's actually even more extreme. There's actually decisions in Hong Kong, even if the arbitrator got the law wrong, we're not going to set it aside. Yeah, because otherwise we'll open up, people always get the law wrong. It's purely, it has to be in a breach of natural justice. So the arbitrator's done something like decided on a point that wasn't put to the parties, or decided on a point that they hadn't had a chance to argue properly. So that can be very important. Location of sittings. This used to be a lot more important. The pandemic has thankfully changed things for all of us. I remember sitting a few years ago as an arbitrator and having literally a room full of 30 or 40, 50 people, because we've got experts, we've got counsel from overseas, we've got various people all flying into Hong Kong at great cost to the clients to just be there for the arbitration. The pandemic has taught us that we can use technology for a lot of this. For example, I expect very rarely to see any live expert witness in the future, because people can find experts around the world and their testimony is usually not something you need to decide if they're telling the truth or not. It's really to understand the logic they've used to approach something. And so you can do that by video conference. It's very easy. And so I've done that, and I thought it was just as good as doing it live. It took a little bit longer because of the problems of technology, but compared to the cost of everyone flying around the world, great. We've talked about arbitral, I think arbitral, so skip over that. Discovery or document disclosure. Sorry, I should call that document disclosure. We still call it discovery in Hong Kong. Do you get full disclosure, limited disclosure, or none? That can very much depend on the seat. So, for example, if you choose America, arbitrators there generally order a full disclosure of all documents. If you go to China, mainland China, you'll get almost nothing, depending, unless you have special rules. In Hong Kong, you get a sort of mixed halfway house, some disclosure, but not everything. And that can be very important in IP cases, because if you're a claimant, if you're not getting disclosure, you may not be able to prove things, because all the documents of some type of breach will be in the hands of the respondent. So you've got to be thinking about that when you agree your clause as well. What type of disclosure will be given? Also, what will be given against you, because you may not want to disclose everything either. So that's a balance you need to take into account. Or you can write into your arbitration clause, for example, use the IBA rules on taking evidence is one thing you can do. So those are some of the key points. There's a few others, but those are some of the real key points, practical tips I have around arbitrating. You have to think about a number of things when you're thinking about your dispute resolution clause, even at the point of drafting it.
So we're still in the practical tips section. We're moving on here. Yes.
So this is something that I actually developed on one of the first cases I did involving patents. I think it's very important, if you have any patents involved, that the tribunal give very specific guidance on pleading the views on infringement or infringement, whatever you want to call it, so that you can have a very clear case. And that should require claim charts up front. The parties always say, oh, we don't want to give you claim charts yet because we still need discovery, still need formulation. I say, look, you've got them. I know you've got them. Everyone has claim charts in patent cases. Produce them. We can do it on a basis that they can be amended later on. It's all subject to later discovery or things, but it helps narrow the issues so much faster, and it's something I require up front, and I think more people should. I've drafted, it's in one of my chapters I've published. I actually have the rules there, and we can circulate it to people after this presentation if they're interested in the claim charts, the requirements for pleading. The dispute will very often cover multiple jurisdictions, and that's going. Sometimes you will actually want multiple counsel from different places to give the submissions. For example, if it's covering US patents, you may want a US patent lawyer to come in and argue that. If it's European patents, you may want a European patent lawyer. Although actually, frankly, if it's in Hong Kong or Singapore seated, because our law is based on European law, you don't really need it for European law. But let's say Japanese law, Korean law, Chinese law. I can do the Chinese law because I practiced for a long time. But those different type of law, you may need it, particularly if you get down to an issue that's not been clearly decided. And you may want the counsel to make submissions. You may also want experts, and occasionally, although it's pretty rare, you can have experts on law. Very rare, because international arbitration is meant to take the view the arbitrator can decide all this, but there may be times when they say, I want that. Your technical expert should be able to cover everything, because technical person's a technical person. And as I mentioned before, I think with the advent of video conferencing, the good thing now is you can find technical experts anywhere in the world, as long as they're willing to possibly give evidence at 2 in the morning, because sometimes that's what happens. But you can find people from any of the world now if they've got the right technical expertise. I think that's very important and a big change, which we can thank COVID-19 for. We can't thank COVID-19 for much, but we can thank it for that, and technical advances everywhere.
All right. Is there something in particular that you would say about handling Chinese parties in arbitration?
Yeah, these are just some general comments that I found from both acting as a counsel and sitting as an arbitrator, and having litigated in China for many years when I was based there and recently. To take a step back before we get into what's on the slide, Chinese civil litigation rules and civil procedure laws put a very strong burden on whichever party is asserting something to prove it. And so that's developed a custom and practice for most Chinese parties in courts in China to not engage strongly with the case in terms of making their own arguments. They just put people to proof and say you can't prove it. And the Chinese courts will often decide cases, although it's improving now, but they'll often decide cases on the basis there's insufficient evidence. So, and Chinese parties bring that mindset to arbitration, and it can get them in big trouble. I've seen cases where I think they could have done much, much better if they'd been aware of the different procedures and rules. So, for example, pleadings are not important in Chinese court. You plead a case, but it's not really, it's basically infringe the patent. No, I don't, if you even respond. But it's what's decided after the hearings that really counts. Document production is very rarely ordered in China. It's changed a little bit now, but nothing like you get in an arbitration. And so they've suddenly been ordered to produce documents that that they wouldn't have to produce in China. And then their witnesses can be cross-examined. So even if you don't produce documents, if they bring a witness, that witness will be cross-examined, which doesn't happen in China. There's no cross-examination of witnesses in China other than experts, but not factual witnesses. And that's a big change for them, because you can create a beautiful case based on what they presented, but your witness gets asked a question in the witness box, and they can destroy the case for you. So yeah, no, we did that. If they're not prepared. And finally, tribunals will draw adverse inferences, which can create a problem. It's a real difficulty for Chinese parties. I know there's a number of people from China looking in. They're probably more sophisticated than that, but it does make cases interesting, shall we say. And it's changing. I just sat as an arbitrator when the Chinese party was very engaged and knew exactly what they're doing. So I think some do take the advice of the council now, but I have seen this quite a lot regularly.
All right. Should we summarize, or should we have some questions? See if you have some questions first.
I think so, yes.
So let's go on to, there's our questions.
Yeah. So we will invite everyone to ask questions. There's a chat function in the
we have a
live broadcast
question here. Doug, I think this is for you. Where do you see arbitration going forward in a few years in China?
So in China, we're going to see a lot more arbitrations involving Chinese parties, as I mentioned, because of the inability to enforce contracts, foreign judgments in China. Most contracts have arbitration clauses. Chinese economy is slowing down at the best. It could actually face some real road bumps because of the property developers are very short of cash, if not extremely short of cash. They're teetering on default. And that's going to feed through to the economy because GDP growth has been driven a lot by property development. There's the trade war, there's other things, and you do see parties being unable to deliver on their contracts, or Chinese parties have become more sophisticated. I've now seen them bringing claims themselves, saying you didn't deliver the proper technology, you didn't license us properly. So we're going to see a lot more arbitration with particularly Chinese parties over IP issues. There's a lot of cases coming through, and there's going to be a lot more. What's interesting is, and it doesn't feed through the statistics, is very often a case starts as a contract claim, say for royalties, and it's not even treated as an IP case because it's a contract claim, or it's, but then the response often then turns it into an IP case. Well, you know, the patents are invalid, or these other things. So some of these institutions aren't picking that up in their statistics. So I have one case right now where it's not categorized an IP case, but it really is at least half an IP case because it now all involves IP issues.
Was there any questions in the chat?
No, and also for all your attendees, you can also ask if you have specific problems, or a question can be very broad here. So we'll invite you to ask, to write some questions, and I'll put them up here.
Should we take the key takeaways as the...
Yeah, we can get to that and then
come back to, there we go.
Back to questions.
Yeah.
So to summarize, some key takeaways: arbitration can be a good method for solving disputes, but parties need to be aware of the advantages and pitfalls with arbitration, not just when a dispute has already arisen, but when drafting the arbitration clause, or even when deciding to arbitrate or not. And seed of arbitration can be important. Doug, you've been talking about this. So regarding this, maybe I can put in a question for you, Doug. Is there a situation when you would say is typical where it's better off to choose litigation before arbitration?
I think if you need interim relief, litigation is always going to be best, even if ultimately you arbitrate. If you think your main relief against people will be interim relief, arbitration can be dangerous. So I had, for example, last year 2 cases involving franchises, and the franchise was terminated. Franchisees refused to stop using the trademark, saying you haven't terminated, being able to go to court for interim relief would have been much more effective for my clients than arbitration, because and of course we could have gone to court, but we had arbitration clauses that actually had some escalation clauses, which is something very common as well. So you need to discuss, you need to mediate, then you need to, and you've got to be very careful with escalation clauses that you don't run off and get an interim injunction and cause problems those as well, because you can then get yourself in trouble under the agreement. So even when drafting a clause, you really do need to step back and say, what is going to be my main claims here? Of course, you put in most agreements the very clear wording that either party may seek interim relief no matter what, but sometimes it's not there, or sometimes it's still caught up with an escalation clause. So there are times like that. The other times are, this is small. If you think your damage, your monetary claims are going to be relatively small, and of course for each company relatively is going to be a different number, but let's say under $100,000 or even a little bit more, you may actually just be better with a litigation clause, because arbitration takes time. You've got to appoint the arbitrator, you've got to pay them, it takes money. For simple monetary claims, courts around the world are generally better. You just bring the claim, you claim the money. Many places you get summary judgment, but if you don't get summary judgment, you're on a fast track, and it costs you far less, and it's far more effective because court judgments are usually enforceable immediately, they're granted, as opposed to arbitration awards where you've still got to go through another step to enforce it. So there are times when you really have to take a step back and say, what are we going to do now? Just to finish that thought, sometimes you'll do this analysis and say, well, actually, we do want to arbitrate certain things and we do want other things we don't. And that's where you may want to say, well, we need 2 contracts. So, for example, if it's just the sale of goods where you're going to be claiming money, you can say, okay, we're going to do a sale and purchase master agreement where we just put in litigation. and then we're going to do a license side of things where we will put arbitration. Just one tip on that is you should specifically cross-reference in each contract that you know you've done this. Otherwise you get arguments. Oh, well, we've got two conflicting clauses. You kind of meant that. But if you put it in very clearly, yes, we know that these are contradictory, but we've done it on purpose, then you'll usually have no problem later on.
I will just a quick add on there when it comes to arbitration. Many of the institutions now provide for expedited rules and
Yes.
for claims that are smaller. So in the arbitration clause, you can put in a provision stating that if the claim is for a certain amount, then the expedited rules are used, and then the cost of the arbitration is less.
Much less. That can also save you if you've agreed 3 arbitrators, but it's a small claim, because if you go under expedited rules, usually it becomes 1 arbitrator rather than 3, which is also a cost savings for a small claim.
Right. Was there anything you would like to add, Love or Clive, about the key takeaways?
There's a lot to consider when you draft the contract, I think. Obviously, it's hard to imagine what will happen in the future, but arbitration clauses are usually called the midnight clause because it's in the final sections of the contract. So maybe it's not being considered as much as it should be. It could be very important if a dispute arises, even though in many cases it does not. So I think that's interesting. Okay, we have a question here. We'll publish that. So the question is, for Doug, where do you see the future development of IP arbitration in Asia?
Okay, so broader,
but yeah.
So broader than China. Okay, that's good. I think we're going to see a lot more IP arbitration in Asia generally as well. India, I think you'll see more because as Indian parties get involved in things. I think as people get used to arbitrating IP disputes and there's more knowledge that comes out, all the institutions now are starting to publish a little bit more about what they've been doing. WIPO has a very good information on its website. HKAIC from the 1st of December will be putting small case notes out so you can understand what's going on. As people get familiar with it, you will see, I think, more parties willing to agree to arbitrate, but even as submission agreements agreeing to arbitrate rather than going to court. And that includes as parties become more sophisticated, particularly in China, but in other places as well. So I see a bright future for arbitration in Asia. But I think the most important thing, and Lava just mentioned it, everyone, including me, but everyone has to spend a lot more time on their arbitration clauses and the rules they want to apply up front. Lova said it was the 12 midnight clause. Frankly, I've always negotiated them at 3 a.m. in the morning or 4 a.m. in the morning, and everyone's half asleep, and you end up with some pretty poor stuff. You almost have to, when you're preparing, have multiple possible clauses that you can agree as you go through them, rather than sort of changing something at the last minute. So if you put in, for example, arbitration in Stockholm, and the other side said, absolutely not, we're not going to arbitrate anywhere in Europe, and we have to be in China, and then, as happens very much, okay, how about Hong Kong? But if you just write Hong Kong in, you don't know what you're agreeing to. And sometimes you've agreed to something you shouldn't have agreed to. So that's a big thing that people really need to be conscious of as they're drafting arbitration clauses.
And to choose an institution which has knowledge within IP, because we know it's something that's hard for us lawyers to understand the technical issues that may arise, and then also to have an arbitrator which has experience in handling technical issues. And is interested in actually in handling these issues.
Yes. Yeah, interest is very important.
So motivated.
Yeah.
We have one slide, I think, when Rouse offerings, or
yes,
we can finish up that. We only have a minute left. We're cautious of everyone's time. So we had a slide prepared. What does Rouse offer? Obviously, arbitration and mediation, which usually comes before arbitration. Then also litigation support to support arbitration when you have to enforce interim injunctions and awards. But also I think something that is very important, a pre-dispute analysis before you throw yourself into arbitration or litigation. Is there an infringement of the IP right? Is it valid? To this note, Rouse has a technology hub around the world with patent agents and experts who can advise on the forms of technology to evaluate the IP and see if it's actually infringed or not, or if it's valid. So I think that's very important and something that's being not missed, but something to spend money on, I think.
Yes.
Okay, I think we're at time, right, aren't we?
Yeah.
Yep.
Yeah, well, thank you then to everyone. Thank you to Moni
Yes.
and Lova. We'll be circulating these slides, won't we, Lova, I think?
Yes, and the recording and the slides. So, and then perhaps sometimes we will follow up with a call to the attendees as well and see what you thought of our presentation.
Okay.
Okay. Thank you.
Thank you. Goodbye, everyone.
Bye-bye.